recording at some point?
Yep.
There it is.
Okay, great. I've got 12:03, and I will start my cute little draft minutes in another document. All right, I have that. Harry, I think we're waiting for them to submit their redlined options, correct?
Yeah, I think where we left off at the last meeting was you were going to take some time, kind of circle up, and then maybe present some red lines for us to take a look at and see where we go from there.
Yep, and that's where we are. We have two versions. I sent you a little message. We had an internal conversation, and we want to explore the possibility of a part-time release and how that might work. So I have a draft that kind of incorporates that concept into it. It doesn't. I think you'll see it doesn't address what the assignment would be, right? He'd have to work that out with the district and work the individual school site, but the concept that contained in there, and then also to our conversation, I've added one that's kind of more in the line of a full-time release, the way that President Resinetti's was kind of set up, and very similar. So I don't know if I have the ability to drop things in the chat or not. Let's see, or if I need to email it to you guys.
I'm not familiar with restrictions. I think last time everyone was able to.
Yeah.
It says I need something.
It does?
Else. OneDrive. I have OneDrive, but for whatever reason, it's not reading my OneDrive.
I did, when I did it with us, I did that little plus sign, and then I did upload from this device. That's all I did, but I don't remember getting prompted for a OneDrive.
So it wasn't actually through the chat function?
Yeah, I did it. I did the meeting chat, and then I just did the little plus where it says actions and apps. And
see, all I have is I have a little attachment symbol. I don't have a plus. I have font, attachment, important, and smiley emojis. But my attachment says I need a OneDrive.
If you email it to me, I'll just upload them into the chat if that works for you.
Sorry about that. Yeah.
Or this.
Don't worry.
Whichever one. Oh.
I'm better at Zoom than I am at Teams, apparently.
Okay.
Likewise.
You should receive the email, Terry. I just sent it to you.
Okay.
So you should see it.
Tell you when it pops in.
It makes it through our firewalls and such things.
All right, just got them. So let me save them real quick. Which one do you want me to? I'll just put them both in the chat, and then I don't know if you'll be able to manage it while it's on your screen.
Yeah, I should be able to. They're very similar in terms of like the changes made to the full-time are similar to the changes made to the part-time. There's just kind of a addition of proportionality and some of the financial components, but so we'll start with that one and then go to the other one.
Let me see this. Okay, select the edit. All right, so let me add attach file, upload. I don't know if that went. I did the full time.
Okay.
And then I'm gonna do part-time separate. See if it lets me do it.
Yep. It looks like we have that one.
But I think it may not, well, that one failed to send.
May not let you do two at once.
Or just may not let you modify it because it's shared, I guess. I don't know. It's trying to send it again. The part-time one, I just clicked the same thing I did, and it just says it's waiting. Still says sending. Do you want to start with, I guess, the full-time, and then whenever the part-time
Sure.
goes through?
You guys have that on your end, the file there in the chat?
Yeah, it came up for me.
I'm having to
do we wanna just-
authenticate to open it.
Yeah, same on my end.
Or Martin, you can just email it to everybody. I mean, it's been shared. So if you just want to email it to the whole crew and then they can just all open it separately, might be easier. And then you can just share your screen and pull it up.
Julie, what is your email? It's not popping up.
SESSAJ@martinschools.org.
Is all right. Should be in your email inbox here in moments. Let's see. You want me to go ahead and share a screen here? Is that the preference?
I think so, if you can.
Is that sharing?
Not yet. Yep.
Okay.
I s-
Is it
I
the
see it.
You see my mouse moving or whatever on there? So we're talking about the same thing. Okay.
Yep.
So this is the part-time. Like I said, there's going to be a lot of similarities across both of them. So you'll see what we're talking about. I changed the kind of introductory paragraph instead of addressing the unpaid leave to just say the leave status, just to acknowledge that. I don't know if that doesn't make a major difference to me, but it is just kind of a wording change. Let's see. We changed, just for your edification across all of it, we changed just Theobald to Mr. Theobald. That was a preference. So it'll show that changing throughout. Number 4, where it starts to get substantial, just released added part-time from his duties. Again, we have that to be addressed as to what it looks like. I didn't know on your end if there was a specific title if you had part-time teachers. I don't know that, so I left it as teacher on special assignment. You'll see that just because I figured the special assignment may be the part-time assignment. It may not. It may be you may have another title for it. I just wasn't aware of that, and so I didn't make that change. And then I removed that Mr. Theobald will report to an individual to be determined by the superintendent, because in a part-time status, of course, he would be reporting to his administrator, or wherever his position is, his supervisor through the school. Again, I left it as teacher on special assignment there. And what'll be in number 5 will be consistent kind of throughout is the idea that the MCEA would pay for, again, the whole idea remains the same, that the school board is never out any funding as it relates to Mr. Theobald's service as MCEA president, right? So the difference between a part-time and a full-time is that obviously he would still be able to be paid for his work for the district. He wouldn't be able to be paid for his work through MCEA. And so we reimburse that portion of the salary, benefits, whatever that proportion may be, whether it's 51% or what have you. We'll reimburse that proportionate. And so I've kind of added this proportionate to the part-time status in this document to reflect the concept that we will continue to do the arrangement we talked about under full-time status, just on that part-time status, proportionate part. So you'll see that kind of throughout. Again, number 6 is kind of the same idea. The portion of his service in the capacity of president will be, will not, the board won't bear those costs, right? Obviously, those costs will be borne by MCEA as we've discussed throughout. And this is, again, for this portion, proportionate to the employer contributions. Like you'll see that throughout, the concept being that proportionate breakdown of the pay depending on his proportion worked for the district versus worked for MCEA. We left the same thing for the prepaid month in advance. Figured once we establish that will remain the same, and we'll be able to continue that prepayment process to ensure, again, the point being that the board will never have incur any cost. They will all be prepaid. It gets we tried to address in 6 here, B, I think it is, should additional payment be necessary in the event of unforeseen costs, they'll remit payment within 7 days of receiving an updated invoice. My assumption is that, like we talked about yesterday, the board will be aware of those costs in advance, somewhat in advance, even if it's after the initial invoice, but still before that subsequent month. It would kind of have to be, just by virtue of the function of payroll and the function of employment practice. And so as soon as that's aware, the goal, again, I know I keep saying this, but the goal is that the board doesn't bear any costs. And so the idea is, as soon as we're made aware of that invoice, we'll pay it. I put 7 days, but we'll have whatever conversations needed to ensure that that's paid on a timely basis to meet the goal, right? The overlying goal of this whole thing. 6C, again, the main changes they're proportionate to his assignments. And the workers' comp piece, we'll see down a little bit below. But again, same thing. I was able to confirm that the workers' comp is correct to be done through FEA's workers' comp policy. MCEA is covered under that. And as Mr. Theobald's operating in that capacity as president, the claim would be appropriately made through FEA's workers' comp, not through the boards. And so I think that won't be a problem. But the idea there being that in a part-time capacity, and I reviewed a few others, that if he's working as a teacher or whatever he's working at, and the injury happens there, that would be covered under that portion. And whether there's details to be worked out on that, I think it worked in the other situation, so I assume it works. But I'll defer to you guys on that. I added a number 8 there just to address the fact that again, he won't receive leave for the portion, proportionate to a time, as I keep saying this, but proportionate to the time that he's serving for MCEA. Obviously, the board wouldn't be responsible for giving him leave for that time, and he wouldn't be responsible for taking leave for that time. The opposite is therefore true, right? If he's working for the board, he would be issued leave proportionate to that time he's working, and he would be taking that leave with his administrator in that capacity, right? And so that will be the same proportionate relationship. Number 9, I kind of took out a bunch, right? And it's a big one, I know, for you guys. The idea being that that anything that he does while working for MCEA is you're not liable for. I mean, that's the ultimate goal there. But, what we are concerned about is that, if the health insurance program, if there's an issue with the way that it's facilitated, if he's discriminated against by not being given health insurance where he otherwise would be eligible, or what have you, whatever the issue may be, as covered under that under that program, he would have the same recourse as anyone else covered under that program, right? That the idea there, I think, is that that any claim that's left with any claim, damage suits, or other form of liability brought against the board by any person at any time arising from any act or omission of Mr. Theobald, which occurs while he's acting as the president of MCEA, that's what you're indemnified from, right? So if he's in the capacity of MCEA, there is no claim to be made against the board. FDA covers that. But if there is something that occurs to him by the board, right? Again, we're talking about, something that's really unlikely to occur. But if something happens to him by the board, pursuant to the health insurance arrangement, pursuant to any other benefit that he's eligible for, he should have the recourse given to anyone else that's under those plans, right? He should be able to challenge, health insurance determinations like anyone else, right? And I don't know if that was your intent in this language, but it left open the possibility that somehow he could be denied health insurance for an illegal or improper reason and not have any recourse because he's an MCA president. I don't know that was your intent, but it gave that opening to me. And I think it's covered just by much more simply saying, listen, when he's acting as MCA president, MCA is liable. When he's a board employee, board's liable. That's kind of the standard thing. Like I talked about, this is not going to come to fruition, right? Filing a workers' comp claim against the board, right? Unless he's working in the capacity as a board employee, because he's covered under another workers' comp policy, and that's the appropriate place to go. But we left that in there, right, to ensure that if for some reason he did file it, in that case, that would be incorrect, but that it would not, we acknowledge it would be incorrect, right? Essentially, we would hold you harmless for that filing. We left the same 10 as far as subject to the terms of annual contract, collective bargaining agreement, policy of the board. I tried to get at the conversation we had yesterday by just saying he'll maintain all rights provided by law to a union officer while acting in that capacity. It could be a union member, could be a union anything, right? But the idea being that just to acknowledge what I think we all agree with, that he has rights and they are separate from what we're not trying to undermine or infringe those rights by saying he's subject to the contract. And I think that's correct. And again, just added part-time to 11. Sorry, it seems to keep popping up. Added that we would attach the teacher on special assignment to the contract as Appendix B. I think Appendix A was something else above. So I added as Appendix B. I think we talked about that last time. It's essentially just the annual contract. And so that shouldn't be any concerns, but we will put it on there so that we're all talking about the same thing. Again, 13, we talked about this verbally. I added a sentence there, that doesn't absolve either party from implementing remedies stemming from the award. Again, I think that was the intent. I just put it in there to avoid any potential disagreement on there. And then, as we discussed, I removed 15 as repetitive of something that we've already acknowledged by the fact that this sunsets at the close of business on June 30th. So that's the part-time one. It's going to be, you're going to find it very, very, very similar to the full-time one, in that the only difference is that we changed proportionate expenses to the other. So I'll pull that one up if that is what makes sense, or how do you want to proceed on that?
I think just go to the full-time one, and then I'll throw in my comments initially on all of it, would be my thought.
Get the other document.
Yeah, I agree with that, because we just want to make sure all of it is in the sunshine, the part-time and the full-time.
No. Absolutely. Let me zoom this back in. Sorry, I had it small on my screen to make sure everyone can see it. And this one. should be coming up momentarily. Is it on your
Got it.
screens yet?
Yep.
Okay. And this is the full time, like you said. I mean, the didn't change as much, but the same things have changed. We added Mr. Theobald. There was a repetitive only apply in my version for whatever reason, so I took that out. But that's I think I took that on boat. I didn't mention that the first time. It was repetitive. It may have been an addition by me that I accidentally added and then deleted. So I apologize. I took out in number 4. That Theobald will report to an individual to be determined by the superintendent. I don't know how we necessarily want to address that, but we're not going to agree to an MOU that has the president being reporting to the management. You know, I think that's going to be a problem for us. Mr. Theobald, I just added or MCEA to this one to ensure that, you know, the you're getting paid, you're getting reimbursed. You just want to make sure that it's clear that it may come from him or may come from MCEA. There are changes here. Same change to 6. Additional payment be necessary in the unforeseen in the event of unforeseen costs. We'll remit payment upon receiving an updated invoice. Again, I think there's some wiggle room about the timeline of that. I don't know what changes would be likely to occur and when those changes would be likely to occur. My thought was about a week would probably suffice, and that would just kind of create a deadline. Obviously, there's no restriction on paying that faster as needed. But again, the goal here, I think, is very clear that we don't want the board to be out any money. We understand that would be a problem for both parties. So we don't want that. Again, same reason above. I took out the annual evaluation by a supervisor designated by the superintendent for the same reasons as before. I don't know what would be evaluated, and without having that evaluation, I've sought some information to Ms. Sessa's comments before about, well, there are potentially salary types that are related to evaluation awards. I don't have an answer to that quite yet. I mean, I don't know how others are doing it. Clearly, it's being done around the state, but I don't know how that's being done. I don't know what specific salary classifications those are and when they go into effect, or whether they go into effect from this year's evaluation or last year's evaluation. I don't know the nuance of that. It's something worth considering, but again, I think it's easily, to my mind, and again, this is Ms. Sessa, this is on you, so I shouldn't probably say easily, but the fact that Ms. Resinetti was somehow able to do it without having an evaluation suggests to me that it's workable if we want to work it out. And so I hope that we do, but you know, without having an idea of what the evaluation is going to be about, I'm real hesitant, and we're real hesitant about subjecting him to an evaluation by an unknown person, unknown designee of the superintendent for unknown standards.
I mean, I could offer some comments. I can wait till you're done, Martin. I'd happily do that.
Okay. Well, why don't we? I'll just finish running through because I think it's almost done, and then we'll open it.
Okay.
Same thing on not requiring him to notify the board about his leave. He's not going to receive it. He's not wanting any value that he hasn't earned, but he's also not going to be advising the board when he's taking it, because of course he doesn't have it to take. Same conversation on what's now 8 in our proposal, which is that, you know, I think we had that conversation. The idea is that you guys are not liable under any circumstances for actions taken by MCA president, but that he should have the right as any other covered employee for the policies and plans. I added incapacity of the MCA president here, just to be clear. That again wouldn't be an issue. I think it makes the board feel a little bit easier to have it in there, but not an issue. He is covered under another workers' comp policy, which will be the appropriate policy for him to make any complaints on, and he understands that. We understand that. That would be our plan. I left the same number, what's now number 9, maintain all rights provided to a union officer while acting in that capacity, just to ensure that we have that meeting of the minds on what the intention of that section is. I attached the special assignment contract as Appendix B. Same kind of caveat to the arbitration award, and removed the past practice precedent restriction in that it will already sunset at close of business in June 30th. So as you see, they're both very similar. The only difference is how we coordinate, if there's a willingness to discuss the part-time component of it. And I did review the contract. It doesn't specifically say full-time or part-time. It just says be released on some unpaid status. And I think to my reading, that gives us the ability through bargaining and MOU to address that. Our hope, again, we've talked, I know I say we, but MCEA's talked about it with their board. We've heard numerous occasions what the school board, the district school board, has said about these leaves. And so I think it solves or addresses, maybe not solves, but addresses concerns on both ends. And I think, if there's an appetite for it, it would be the preference of MCEA to move that direction and try to work that out if it's possible. And so we wanted to present that opportunity to you guys today, and see if before you had a conversation with the board, go ahead and give you some thoughts about that. There may be others that Gary or Matt have from kind of a practical standpoint of how that might work. But again, like these release time components, I mean, Terry and Jeff, you guys know this, and everyone on this call knows this, I guess, but they work around the country, around the state without much concern. And so they're clearly doable if we want to do them. And I hope that the fact that we're here indicates some willingness to kind of try to find solutions to it. So that's why we went ahead and proposed it, because we hope to try to find a solution to it. But we're open to your thoughts or concerns. So I'll stop talking now. But Gary or Matt, did I leave anything before we turn it over to Terry and Jeff? And did I miss anything? Did I leave out anything? Okay, that's it. Do you want me to stop sharing? Do you want me to leave us on the? We all have it up on our computers.
I think leaving it up, if we just want to go through, and Julie, I think maybe if we have Jeff also, if you want to go to just page 1 of, I know the part-time, I guess pull up the part-time one, because really the changes are the same for the most part.
I'm wondering if I can just change it. Does it change the document when I just change the screen, or is it specifically sharing that?
It looks like it's changing.
My screen there, because I
There you
only
go.
showed part of it.
Okay, I didn't know if it was doing the screen or the specific document. So you hopefully have the part-time up now.
I think so.
That's full-time.
Yeah, that says full-time in the body of it. Yeah,
All right,
you're right.
Give me 1 second. I think maybe it's just sharing a specific window. Okay. Oh no. Load up here, get the zoom back. You guys showing something on your screen? Maybe it's the right
Yep.
thing, maybe it's not. Certainly
Part-time.
something. Okay. All right. And let me know what you need to scroll or whatever.
Go down just to number 4. Start at number 4 if you can. Okay. I mean, really, I'll go first, I guess. It's really part of this first page, and it's just who to report to and evaluations. I just don't know how practically, whether it's full-time or part-time leave. If it's part-time, understanding that, as when you're serving in the instructional position, that, the evaluation process is easy. But when you're serving in a role that's carved out as temporary duty or whatever we call it, whether it's part-time release or full-time release, I just don't know about how we would have an employee not in some way still being assigned to a supervisor and having some form of evaluation. And I'm not saying an evaluation about are you doing what MCEA requests you to do? I think it goes back to where we were talking before about more generic. Did you comply with all board policies? Did you comply with the code of ethics for the education profession? And I mean, I'm not trying to overly complicate it. I'm just wondering if there is a workaround there. Because if we have to evaluate, we have to evaluate. And so just trying to figure out I don't know what the solution is there. I get your concerns.
Is
Completely.
there flexibility on the tool? I mean, because there's not going to be a tool in creation to do what we're doing, right? I mean,
Right.
I don't think we'd have to make it up, right?
Yeah, and I know I just don't know, admittedly, where there's what the evaluation process others may have been able to get by through audits or whatnot that have been acceptable for an evaluation tool. I don't know the Miss Ressiniti part, how that was conducted, but on a looking forward basis, I think Julie made a good point. Like if there's a highly effective or effective, there's a salary differential there. And just how would I just don't know the answer to that. I'm not exactly comfortable though, just saying no report, no evaluation.
No.
But I'm
not
also,
I can
Go ahead,
input
Julie.
a little, Terry, that
yeah, please.
I mean, Matt's even on the team. We're redoing the teacher evaluation based on new statutory changes and a negotiated piece where we have union members on a team to do the teacher evaluation. So if this is the part-time release, Matt will get a teacher evaluation, even though he's working part-time, based on the new evaluation that's put together by the team that's working on the edits right now. But evaluating as far as the other half of the day where he's on presidential leave, I understand what Terry's saying. If we want him to follow policy and procedure when he's on in the CBA, when he's on campus, when he's not teaching. So I think that's what we're talking about with this partial release. One is going to be the canned response. So we have an evaluation and he'll be teaching and he'll get an evaluation from his school administrator, and that's not outside anything we already do. But I think what's a question is afterwards that we could get from our board members that we're addressing with the indemnity and those other pieces that they brought up to us is there not necessarily evaluation, Terry, but just making sure he's acting within the course and scope of his job as the president, and then what things do we need to make sure we have in there to protect the district while he's on our campus and working with our employees. Is that making sense?
Mhm.
Okay.
Yeah, just is there?
It makes a lot of sense. I mean,
Go ahead, Martin.
sorry. No, it makes a lot of sense. I mean, I just practically don't know how we solve it, right? I mean, even if it's, let's just say, because I think we would probably hold relatively firm to like it's the superintendent, right? If he's as MCEA president, he wears a hat very similar to the superintendent's in that capacity, so he shouldn't be evaluated by anyone else, but someone that's got that level. But even like compliance with the CBA is a subjective thing, and it is inherently conflict, right? Sometimes, not always, but like the reason that we have two sides of this sometimes is that we say we are complying with the CBA and the board or superintendent says we're not, right? So how does the evaluation work out if the evaluator says Matt's not complying with the CBA when he's at school, and we say, wait, no, he is? You know, it's inherently problematic because there is no standard like there are with a teacher, that there is like you said, there's a committee identifying what the goal and the purpose of this role is, and that goal and purpose is defined externally to the school board, right? It's defined by MCEA, right? So how do we, I mean, we could have his board evaluate him, right? I mean, they probably already, to some extent, I'm speaking out of turn, obviously, but like somebody who's actually like got some authority to identify the roles and responsibility and goals, then whether he's meeting those would be, I don't know how we come up with, unless it's like, you know, school board policies and ethics and, you know, that's, you know, very simple terms, like just basics. But to the extent we bring in any collective bargaining, any grievance representation, any of the union role, I don't see how we can agree to that. I want to come to an agreement. I understand your concerns, and I think you understand mine, but I don't know how we would accept that. I just don't know that we could. Gary, go ahead. Sorry.
Yeah, so the only thing that I wanted to contribute with that is that it gives us more of an incentive to lean towards the part-time, because then that question gets answered through a part-time implementation, right? So that's a selling point to transition towards or take into consideration a part-time request more so than the full-time request. The other part about the full-time request that I just want to put on record is that what made all of this transpire and take place in the first place was the issue that was being raised on who was proposed to evaluate Karen Resiniti during the implementation of her past release, right? So the concern that was brought on record in the school board meeting was the fact that Tyson Bilwak, who was on the bargaining team, was evaluating Karen and the conflict of interest that presented itself through that dynamic. So if we're looking at the full-time release and the appointment of who is going to supervise or evaluate her, wouldn't that conflict of interest argument still exist? And that was the main hangup with Karen Resiniti's release, was the conflict of interest and who was going to evaluate her. So I just think that if we can focus on the part-time release, that would alleviate us from even having to ponder over that question and get us closer to a resolution, because that question isn't even an issue with respect to the implementation of a part-time release. So if we're considering full-time release, we have to consider the dynamics of who would be in this evaluation or supervisory role from the initial outset of it, to avoid that conflict of interest that presented itself in President Resiniti's implementation.
So what you're saying is, in the part-time scenario, there would be the regular classroom duties evaluation, and then when they're on, whether you call it leave or release, there would be no evaluation connected to that time?
Correct.
Right.
And Julie may be able to answer this question. So if someone is on unpaid leave, are they evaluated? So I think that's answering that question too. That would make him he'll be the only one that would be applied to with respect to all other board employees that are on unpaid leave. So this collective bargaining agreement doesn't have a requirement, nor does board policy, to my understanding, have a requirement for those that are on unpaid leave to be evaluated. So why would President Theobald, when we're establishing in the very first sentence of the full-time release that it's unpaid leave? So if we're establishing in the very first paragraph that it's unpaid leave, then why would we have to justify doing an evaluation, and he would be the only one that would be on unpaid leave being evaluated? I think that separates him from all of the other employees of the board that's on unpaid leave.
But Gary, I think, when you compare it to Miss Resiniti's leave, there was pay for performance, and she was receiving the benefits as if she was teaching, right? She received all her benefits as if she was teaching. So I think they were just trying to, and it was our first time doing this ever,
Right.
since it was a contract from 1999. So they're trying to toll all the things that happen when someone is on a teacher on special assignment, so she could get those benefits. So at that time, they were trying to conform with a teacher having evaluation, so they would get performance pay, so they would get the millage, all those other things. So when you're looking at it from this point of view, if the partial release is accepted, there will be an evaluation from a teacher in the classroom perspective. And then maybe just the terms of the agreement can set forth anything else that happens while Matt is performing the presidential duties in the rest of the day, so we don't have any gray area there.
And I guess, is there I think we skipped ahead on what really my biggest question was, trying to anticipate all the questions we'll get. is when you're talking about part-time release, just the concept itself, I know it can take many functions. The draft that you've got right now, I think it just brings up the topic, but it doesn't zone in on like, how does that look? Like, is it working a part of a day? Is it so many days out of the school year you would get for that release? Like, how would you want that to look? Because if you're working, and Matt might be able to correct me, middle school, am I right on that?
No,
I-
I'm a high school teacher by trade, but
I had 1 in 3 shot, so.
yeah. And actually, Terry, not to add salt to the wound, but if of those 3, middle school would probably be the last place I'd ever want to work.
It's the hardest. I get it.
My respect
get
for
it.
middle school teachers is profound for sure. But you know, I think there's a couple of different ways that you could look at that. I actually saw on social media that a teacher was hired on at one of the high schools, and had agreed to a part-time position where she could only work the afternoons. In which case, if there was a part-time position like that, I could serve, you know, in the morning, filling in the other half of that part-time request. And obviously that would be, you know, 5 days a week, you know, subject to the same, you know, school schedule as everybody else. You know, just spitballing, you know, something to the effect of, well, and I know it's still an issue, but it was definitely an issue when I was at Martin County High School. They were always looking for subs to cover classes, and you know, when they would ask for teachers to give up their planning period, and cover another teacher's classes. You know, I could make myself available, you know, for however many periods a day, you know, to cover classes, because the need is great. And whether that's at one school or I think doing it at multiple schools might complicate things, but you know, whatever the need would be, I would certainly be available to fit that need. And then I've talked to some other administrators in the past who have, whether it be, I wouldn't say virtual options, but you know, there are other jobs that wouldn't necessarily require, you know, full-time service. So I think there's at least 3 different ways that we could go about that. It would just be about, you know, filling the need, and also whatever allows me to, you know, serve the teachers, you know, in whatever, you know, whatever capacity. And I agree, Julie. I think whatever we decide would be very specific. You know, I think that that's a necessity, as well. You know, so I don't want to create a position, you know. Well, I'm trying to think of who said it, a fake position. You know, I'm a teacher. I want to be a teacher, and you know, I want to serve the teachers and the students of the school district the best way that I can.
Yeah, and I think it would probably have to mean on a part-time work strategy, whether it's full assignment for the year, for half the day. I think that's probably questions we will have to talk through separate from here, because I don't know from a planning perspective how that would work. That's probably principles, some discussions that we need to have. But the reason I asked just the overall part-time question is obviously I think if that was something that was entertained, we will have to narrow it down to specify part-time means this, so that there's clear expectations. It's this many days or it's this much hours of the day. And the reason I ask also is just trying to make sure that if there is an obligation, because all school districts are required to have evaluation systems in place for instructional and administrative personnel, that if we are placing you in a position that falls under that umbrella, we just got to do it in a way that complies with state law. And so if it's a, so I was wondering if the language release, like if it was release for temporary duty elsewhere, does that create a new position? It may not. If it's a part-time, if you're retained as a teacher, instructional personnel, and you receive your evaluation, the fact that you may be given 20 days, I'm just making up 20 days of release time to engage in other activities, may not draw a requirement along with it that there be an evaluation for those other temporary duty activities that would be performed. So that might give some flexibility versus a full-time, like if you were not working in the classroom and it was a full-time temporary duty position. I don't know how other districts do it. But I just, that's my concern, is it's just making sure that whatever is done, we have to comply with evaluation protocols. And I think also the reality is the timing of this. I will say, I'm not sure that, and Martin, I think you even mentioned it when we met the first time, that this is maybe something coming out of the blue a little bit with the part-time idea. I don't know. Obviously, we have a client we've got to talk to too, to talk through this issue. So that's why I think, at least me personally, I'm asking so many questions and trying to go down the different hypotheticals. It's just trying to anticipate as much as possible, understanding that school year starts in less than 30 days. So there's a little bit of a time crunch here too. So on the part-time, it sounds like at least the concept is more of interest right now, as opposed to we want it to be halftime this. It's more of, are you open to this? And then if so, what are the kind of nuts and bolts of how it would work?
Yeah, I mean, I think we wanted to give you those layout. We didn't obviously know what the board was going to be open to, so we didn't put a full detailed here's how it will work, because it's going to depend on the school's needs, the district's needs, and everything. But to Julie's point, if there is a part-time position already in existence, then that, I mean, again, subject to the needs, right? We want to fill those needs, but if that position exists, then that makes a lot of sense to me, right? If there is someone who's working half-time in the afternoon, presumably there's someone working the other half in the morning, and that position makes a lot of sense in this sort of circumstances. That's, again, Gary may have better opinions. That's how it works in most part-time places. You work half day and work the morning, teach your normal classes under the normal schedule, normal obligations, parent teacher conference, the whole 9 yards. You just work in the morning, and then that, whatever, 12:30, 1 o'clock, whatever time that half day is, you're on leave, right? And that's the same way that this person that Matt just discussed, or the way that the CBA considers Julie's comment, job sharing or what have you, right? That's the concept that I think is probably most often. But to Matt's point, personally, the need has been expressed to him by other administrators, like, what we really need is to help fill these gaps for people who, are proctoring exams, and there's just daily needs, as you guys all know, we all know, and everyone watching probably knows, in the education world, every school has daily needs to fill in vacancies, right? And so if that makes more sense, we're open to that. But if it makes sense to just have like a set, you work Monday, Tuesday, Wednesday, Thursday, Friday, your classes are periods 1, 2, 3, 4, and you have 5, 6, 7 leave, right? Like, that's the way it works for part-time employees. Then that may make it easier for everyone to accept, right? That's already something that happens. And so So, but we didn't know that. And so we just kind of put it out there as a concept. And then we definitely want to agree for both sides benefits to have some, established expectation, right? I think that's right. We just didn't know what that was.
Do you, Gary, does Indian River or Okeechobee do any type of part-time release that we're talking about here that you're aware of?
Yeah, so Indian River's president is on part-time release.
Do they work part of the day and then go on part-time release the other part of the day?
Yeah, they work the first half of the day in the district, and then they're outside of the district. And in that second half is they schedule all of the meetings, all of the meetings that they would normally attend, et cetera, et cetera. So yeah, it's in the classroom for the first half of the day, and by 12:30, I believe, she's released and works the rest of the day in the presidential capacity.
Do they evaluate her in that other half of the day, or is it just the teaching portion of the day? Do you know?
Well, that question came up in our last discussion, but I guess unfortunate for us and fortunate for President Freeland, she was in Greece and she's just returning. So I have to catch up with her this afternoon and get those questions answered.
Okay, I mean it's ultimately it's a legal question that you would think those of us lawyers on the line will be able to figure out the answer, but that's why I'm bringing it up so much. It's just that mandate. So we can figure through that.
Yeah, I think we can confidently say that it's not a foreign concept that we're requesting. It's being implemented successfully in other districts. And while I also have your attention, the questions and concerns about the implementation of the part-time position, how it would work, the hours that he would spend in the classroom and what time he would be released, just all of the bells and whistles on how it would be implemented. Can that be included or contained in the contract that this MOU references would be attached as Appendix B? Because it would prevent us from having to carve time out to try to put that in this document. But when that position is secured and that contract is written, those details could be expounded upon in that contract that's attached to Appendix B, and we may be able to work all of the brass tacks in that manner without holding up the agreement in principle to release them. Is that a possibility?
When you need to have Appendix B, though?
Right?
Sorry, Martin.
No, yeah, I think that's right. I mean, but I'm again to assume that contract exists, right? Just like the annual contract exists, the part-time contract exists if the district's employing part-time employees, right? So that should be relatively easy to come across, I would think. I'm speaking out of turn again. I keep doing that, but
I mean, I think we can, Julie, I think we might have a whole lot more answers after today. Later on today, I think the concept, the ideas, is this doable? Is this not doable? I just think separate from the board, just some administrative level discussions too about implementation wise. And I know it's done elsewhere, but I just don't know as we sit on July 15th, have hiring decisions been made? Is there flexibility for part-time positions at this time? I don't think we know that, but I think those are questions that we can ask once we're done here. But it does sound like, though, at least from what Matt said, that the part-time approach is flexible in terms of, is it mornings, is it sub? And so we'll just have those chats on our end and try to figure it out. I think we just went in with the expectation that we'd be talking about full-time release, just like we did last go around. I think your proposals on that one, really, it's the same questions as it relates to evaluations and who supervisor is. I think those can be navigated to comply with the law, whatever that may be. And the rest of it, I mean, I don't think those are things that we can't work through, that we don't need a further explanation from you on. I feel, Julie, at least, I don't know if you have any further questions on the other portions of the full-time release, just the, the indemnification language. We can work through that on our end and get you some feedback pretty quick. Julie, what about you? Did you have, I think I stopped you at one point where you may have had questions as we were working through one of them.
Well, I was kind of looking through some of my resources on what other districts have partial release. So in Indian River, they don't really lay out anything, Gary, about evaluation, or it just says 0.5. And then if they get the full release grant, they get full release. So there's nothing we can really borrow from there unless there's some internal doc you have access to. And I saw Santa Rosa, Polk County,
Flagler, St. John's.
Hamilton.
Yeah,
And
Blanket.
this was the Fed one. And then I have a whole book of other ones that I think Gary sent me a while ago that I kept copies of. So I don't know if anyone really lays it out, but just knowing Martin County, the more we lay it out and have it black and white, then the less chance we have of a gray area of an interpretation. And that, for all of our benefits, is what I'm looking for. So I don't have to go, oh, geez, what are we going to do in this instance? I want to be able to say it's right here, it's signed off on, it's board approved, and we're following everything. And there's no interpretation, even though I know it still happens because they approve statutes all the time and then we're figuring out how to apply them, right? So but the best we can, that's what I'm really looking for. So I like what we've been talking about partial release. I like the fact that it would be morning. Matt does a lot of committees. I know insurance committee in the afternoon he comes to, and he'll be on evaluation committee for a while. So, in presidential release, I'm sure we'll keep him busy in the afternoon, but maybe the morning work. But again, not knowing or having, as Terry mentioned, time to look through to see Matt's certifications and what openings we have and where he might land is something else we'll have to look at internally as well. So the evaluation part would come from the teaching, because he would be on a teacher assigned, not a teacher on special assignment. He might be, 9th grade teacher at, South Fork or Martin County, or Jensen. So,
And then it'd just be temporary duty leave, basically. So you'd still be evaluated in your function as a teacher. And then when you go do the union activities, it'd be temporary duty leave. Which wouldn't carry with it the evaluation instrument, I wouldn't think.
correct. No, there's no reason to do that as long as you've got what you want in the agreement, Terry, that the board has articulated that protects the district while Matt is working in a different capacity.
Yeah, and that I think, I don't think we will have a difficulty working around that one, coming up with language that's suitable for both sides.
Okay, good.
So I think it's just, I think we have some homework on our end to try to do. What you've presented makes sense from what are you trying to accomplish here? Is it enough for us to be able to break that down and run through our team to see implementation wise? I just was randomly searching for open position, high school teaching positions online while we were talking to see if there were any open. There actually is one, but it's for a full-time position. So we'll talk through and see. I know we are time-wise, we have a meeting at 5 today where we'll be able to get a lot of these questions answered. I still go back, the school year starts on, is it August 12th? Is that right?
That's butts in the seats, but the contract will start, I think it's
August.
the 1st, isn't it?
Yeah, it is. You're right.
So that's when we have to have new educator orientation and all those things that happen at school before our kids come.
Yeah,
To make
you're
sure
right.
we're ready. We have lots of
Well,
law
yeah.
changes, everything.
So Terry, I know you had just said that all the positions you looked up were full time. I don't know. I've not looked at positions in the district in a very long time, but based on the conversations that I had in preparing for this meeting, jobs may be posted as full-time, and it may be the expectation of whatever applicant to find a part-time, a counterpart to their part-time replacement. So it may not necessarily be listed as a part-time opportunity.
Yep.
So I don't want that to preclude, whatever options might be available. But when you talk to the board, I mean, without the administrator that I spoke to said that for the particular part-time application, that was posted or advertised on Facebook, there was only one applicant who came to the district's job fair this past week, and showed up in her farming clothes with ripped jeans. So I may be wearing shorts right now, but I'm definitely not showing up to the job in my farming clothes. So I don't know what other applicants have been, have made themselves available since we had that conversation, but it didn't look like it looked like that position was going unfilled. So so there's at least one solid option there. And as far as teaching out of field goes, and Julie, correct me if I'm wrong, my certificate is social studies 6 through 12. But as long as let's say it's an ESE position, right? I could take the ESE certification test, and I would only be out of field until I passed that certification test. And I've not been out of field in my career previously. So there's that as well. So I'm a pretty decent test taker. So it's reasonable to assume that I could pass any certification exam that I needed to, so long as it wasn't like physics or calculus or anything like that. Full disclosure that is well outside my wheelhouse. But yeah, anything else, I would definitely be able to handle that for sure.
Okay. So then if it would need to take place before August 1, I know we left off on this. Board meetings tomorrow. Then next board meeting after that is not till, you said, Julie said some trim meetings.
Yes, there, I don't know if you can still hear me. I'm grabbing it off my wall because I still hang stuff on paper. So the meeting tomorrow, there's 2 trim meetings, the 22nd and the 29th. And I did mention to Mr. Main, would it be possible? And he said it's possible. He would have to check with the board chair. And then there's a workshop on the 6th, which would still get him in place prior to school starting. And then August 20th is the actual regular meeting. So there is some possibility and maybe wiggle room based on the
Okay.
board chair's approval for an item to be placed on there. So that could be something on the agenda that you and I develop for this evening about timeline and what we might be able to do should we come to an agreement.
Yep.
Okay.
Yep. I wrote them. You got the 22nd and the 29th are trims. The 6th is a workshop and the 20th is a regular meeting.
Yes, sir.
Okay. I think what we should do now then is, do you want to set up a third day? Once we're able to get all that feedback, where we can come back and present any proposals back. Obviously we're on a short window. I don't think we're not working with an open book right now, so there's not a lot to come back with. So scheduling wise, what works, Julie, on your end, and then Matt, Gary, Martin, yours as well.
At least for me, the 18th looks really good. At board meetings tomorrow, we're usually busy, but I could also do something in the morning. On the 17th?
18th is
Um,
pretty good on my end too, for what it's worth.
Like 1 on, I'm good, believe it or not. I'm probably,
Jeff, how about
Working
you
on-
too? I'm sorry, Julie.
no, go ahead. I'll mute myself.
18th I can't do. 18th and 19th I'm out. I can make it work if we need to, but
Okay. Just in case.
I'm good for the 18th and the 17th as well, for that matter.
17th, I can do afternoon would be preferable.
yeah, that works for me.
Anytime
do that.
after
I think, yeah,
noon.
that's fine.
You want
for
to hold
me.
17th?
Yeah, that'd be good.
All right.
All right, are you, I have a program meeting on our volunteers with our principals because we're changing that from 1:30 to 2:30, but I could move it around. I have the room booked for quite some time.
Could you
what were
do
you
it
looking
around
at?
that meeting? Like, what time is that meeting that you have run from?
1:30 to 2:30.
Just want to do it after your meeting if everybody could do that?
Yeah, that would be great.
That works. You want to
I'll
say
block off
2:30?
2:30.
Mhm.
Or if you need
2:30
more time,
to 4:30? Just do 2 hours again?
2:30 to 4:30 on the 17th?
Yeah.
block it off.
Yep.
Terry, as you, just as an aside, as you look at the evaluation requirements, anything on that you can send me out, it's not a legal issue I've ever explored, so I'm going to kind of have to start from scratch on what requirements are held. But if you can point me in a positive direction, that would be helpful. If not, I'll do my own research.
Yeah, no, and I'll tell you the premise that it's coming from is just the general requirement that school districts have evaluation systems for instructional and administrative personnel. And if
Okay.
if a person is placed on unpaid leave, but as the arbitrator said, there's a way to put you in a position to where you're drawing FRS and you're considered to be an employee. How would you that's my issue is like, okay, if it can be done, then how does it not have some evaluation component? With the point that you made, Martin, and I'll reiterate what you said. I don't think we're trying to evaluate whether the MCEA is happy with their president. Nor would you accept that.
I think we're on the same page there, and I just wanted to make sure I'm reading the same kind of requirements to see if I can suggest any wiggle room there. And I don't know that I'll be able to, but I'll at least look.
That's what I'm going to be looking at too. Is if the full time is hypothetically, if the full time's the only option, what can we do there, considering the time issues? Can it
just as a complete non sequitur? Well, no, it's not non sequitur, but I don't know this stuff, right? So Julia will just be like, "You dummy!" But can he be a teacher on special assignment in a non-instructional position? And does that bypass the need to have instructional positions evaluated? I don't know the answer to that, or maybe a dumb question, but you said instructional positions, and it just kind of put in my head.
It's not a thing because he is an instructor.
Yeah,
it'd be the non-classroom instructional personnel, right? There's a non-classroom evaluation.
But all of our MCEA positions get evaluated, whether they're face to face or they're not. They all get evaluated.
That makes sense. Yeah.
On the tool.
Makes sense. Because you got to stay in the bargaining unit, so that makes sense.
Martin, don't negotiate me out of the bargaining unit now.
I know. I just said that. We got to keep you in the bargaining unit.
That's
we got to
funny.
keep you in the bargaining unit. All right.
Got a great white
look
collar
at it
job.
Yeah, I'll look at it.
Okay, so then we're set for this team as come back in the sun on Wednesday, and I think we'll be in a way better spot to share feedback at that time. Does that work?
Thank you guys. Thank you very much.
Okay.
I sent out the Zoom link.
Okay.
We should have it already. And we have the documents we need, Terry, for this evening to share.
Yep.
With the board.
Yep.
Okay.
And then Julie, can we stay on when our counterparts log off?
And Matt, I'm working on your, I got an email that we nuked all your logins or something.
That is correct.
No, no.
Yeah.
And I think it's because you probably don't have a 24-25 assignment. And
Yep.
it's just a thing, that if people don't have an assignment, then we take you out of credentialing for security. So I'm working on the back end with Jeff Raymond and ET.
Okay.
But they let
I
us know today. You must have contacted them. I'm not sure, but
Yeah. I reached out to Katie Bond the same day that we spoke about it here on the Zoom. So, she had said basically exactly what you told me, that it's something that automatically happens, and that you guys are working to fix it. So I appreciate that. The other thing that I just wanted to tell everybody, because we talked about, when we did the arbitration award last time, I was tracking down some bills. So
do you want, can I go off record
We're
for
still
this?
recording. We're still recording.
Yeah, I wanted to go off record for this. So we don't have any more for this negotiation. We've set up a follow-up time for July 17th at 2:30, and I'm going to stop recording now. Sorry, Matt.
Yep. No, that's fine. I was going to ask you to do that as well.